Good evening, everyone. Thank you so much for joining us tonight as we celebrate 60 years of the James Patterson McBaine Moot Court competition. My name is Natalie Winters. I am the director of Berkeley Law's Advocacy Competitions program. I'm so excited to see such a packed house tonight. If you take a look at the program we handed out, you will notice that there are so many people, staff, faculty, students, and current legal practitioners and alumni who gave their time to make this event possible. Round of applause for all of those folks, please. I am incredibly honored to join Dean Chemerinsky in presenting you tonight with an incredibly elite panel of judges who will be evaluating this final round of the McBaine Honors Moot Court competition. I also want to make sure and recognize our finalists before you tonight. A round of applause for them making it here. To my left and your right is Kira Nicolaitis. Why not? Another round of applause. To my right and your left is Chloe Pan. I want to make sure we get started. I know it's a school night. Before we do, some very important housekeeping. I know every single one of you has a cell phone. Please take it out. I will be watching, and put that thing on silent, please. I would hate for it to be something that interrupts the proceedings tonight. I know you don't want to be that person who has your phone going off when one of our finalists or our judges are speaking. I know some of you are still on your phones as I'm saying this, so I'll repeat it one more time. Please silence your phones. Once we oyez in the judges in a moment, this auditorium will be transformed into an appellate courtroom. So please treat it with the respect that that deserves. You're going to hear from the petitioner first tonight. Each side has a total of 30 minutes to present their oral argument before the panel. Once each side's 30 minutes conclude, the judges will retire to deliberate briefly. I promise I will keep them on schedule. And then they will come back and announce tonight in front of you the oral argument champion and winner of McBaine, as well as we will recognize the finalists who made it to oral argument and hand out Best Brief Awards, which are sponsored by the firm Crowell and Mooring. So please make sure to stay with us till the end, if not to see the exciting trophy presentations, then at least out of respect for your fellow finalists and your colleagues who've worked really hard to get here. All right, I know you didn't come here to hear me talk, so I'm gonna get off the stage. We'll get our judges in here in just a moment. Let me close by saying thank you so much and enjoy the arguments.
All rise. The Honorable Chief Justice and Associate Justices of the United States of America. Oyez, oyez, oyez. All persons having business before the Honorable Supreme Court of the United States are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. We have one case on our docket this evening, and it is the case of Dane Sitladine versus United States. It's case number 23-1215-1791. We'll hear first from Ms. Nicolaitis, counsel for petitioner.
Good evening, Your Honors, and may it please the Court. My name is Kira Nicolaitis, and I represent the petitioner, Dane Sitladine. May I reserve 5 minutes of my time for rebuttal?
Yes.
Thank you. Despite their legal status, many of the 11 million undocumented people in the U.S. still consider America their home, living, learning, and working alongside us. Every undocumented person in the U.S. has a different story and background, but they all have something in common. The federal government bars them from possessing firearms, denying them the right to protect themselves, their families, and their homes. Section 922 G5A is unconstitutional under the Second and Fifth Amendments, and we ask this court to reverse the Eighth Circuit's decision and strike the statute down. First, Section 922 G5A is unconstitutional under the Second Amendment. Over the past 15 years, this court has asserted and reasserted the importance of the Second Amendment right to bear arms. In Heller, this court said the Second Amendment codifies an individual personal right to armed self-defense, not a collective right, and described that right as pre-existing and an ancient right recognized throughout history. This court in McDonald said much of the same, describing the Second Amendment right as a basic right recognized by legal systems throughout history. And then a year and a half ago in Bruin, this court articulated the test to use when addressing Second Amendment challenges.
But only for the people.
Your Honor, it addressed what test should be used in assessing Second Amendment challenges. And the Second Amendment does include this term, the people. Now, the government is going to say that this is a threshold inquiry analyzing what the people means up front. But that conflates the two steps of the Bruin analysis.
Is that because you believe that the term the people is ambiguous?
Your Honor, the term the people is both ambiguous, but it also, the government frames it as analyzing the people in terms of who has historically been a part of the people. And that's an inquiry for the second step of Bruin.
Isn't it also a threshold question? What if the Second Amendment said the people born in the United States have the right to bear arms, that the right of the people born in the United States to bear arms shall not be infringed? Are you still saying that the right under Bruin would be only the conduct, the possession of the firearm, even though the text of the Second Amendment under my hypothetical would explicitly confine that right to people born in the United States?
The conduct would still be firearm possession, Your Honor. And then when we look to history, we would see that people not born in the United States would be excluded from the right if that was what the Second Amendment said. But that's not what the Second Amendment says. The Second Amendment only says the people. And this should be considered in the second step of the analysis.
But when you look to key provisions of the Constitution, particularly due process, it seems to allow for rights in which you're going to be infringed upon, like search and seizure, to allow for non-citizens. But you're talking about a specific right to bear arms in the Second Amendment. Do you see not a distinction between infringed upon versus an actual right that is being reserved for persons who are born on this soil?
If I understand your question correctly, Justice Childs, the Second Amendment does include the phrase shall not be infringed. The Second Amendment didn't create the right to bear arms. The right to armed self-defense already existed before the Second Amendment was enacted. So the codification of that right shouldn't mean that non-citizens no longer have access to this right that has existed throughout history. The government...
So can I ask,
Yeah.
so step one of Bruin asks us whether the plain text of the amendment covers an individual's conduct. And I think you were saying a moment ago that the conduct is just possession of a weapon, like by itself. Why isn't the conduct possession of a weapon by, or possession of a firearm by someone unlawfully present in the United States?
The conduct itself is firearm possession, and many people can engage in that conduct. The status of the person isn't part of that conduct alone.
But why is that? I mean, so the statute says the violation has to be knowing, right?
Yes.
And we held in Rehafe that the knowing requirement applies both to the possession and to status as a prohibited person. So doesn't that suggest that the status of the person is also part of the conduct that we're looking at?
The status of the person isn't part of the conduct. That's not necessarily how we think of conduct in terms of constitutional rights. I'm not suggesting that the meaning of the people shouldn't be analyzed at all. Rather, the first step is just about asking whether the conduct is presumptively protected. And then the second step asks whether the government can nonetheless regulate that conduct. And that can be for reasons such as the person's status. The difference between these two approaches was explained by Justice Barrett when she was a circuit judge in her dissent in Cantor v. Barr. She said there are two ways to approach this question of challenges to restrictions like those in Section 922G. First, you could say that certain people fall outside the scope of the right entirely, like the government is arguing. Or you could say that everyone falls within the scope of the right, but history and tradition supports the government's power to strip certain people of that right. And that second approach is more appropriate, and the first approach can lead to analytical confusion. Justice Barrett provides an example on page 452 of her dissent to explain this analytical confusion. Imagine there's a law that says someone with a domestic violence conviction can't possess a firearm for 10 years after their conviction. Under the first approach, the original justification for that law would be that person's status as a domestic violence offender. If that person wanted to possess a firearm 15 years later, but the state they lived in had a restrictive law like the one challenged in Heller, if that person wanted to bring a lawsuit, there would be this standing question of, does this person even have Second Amendment rights to begin with? We avoid that analytical question by saying that the government can strip certain people of their right that already exists, and that affirmative action by the government is what we analyze in the second step of Bruin.
So do you think the Second Amendment applies outside the territory of the United States?
No, Your Honor.
And why is that?
Because I take the people to mean everyone who is in the United States. It can be compared to the Fourth Amendment in Verdugo or Quides. The court refused to apply the Fourth Amendment outside the bounds of the United States.
Well, so I mean that's fine, but then it seems like you're agreeing that whether somebody is part of the people is part of the test. You're just disagreeing about what the people is here, right? So that's not a step one versus step two question. That's a scope of the people question. Is that right?
I would say perhaps it is a threshold question, but the threshold question covers everyone. It covers everyone in the U.S. The government has tried to define the people in terms of political rights or being involved in the citizenry, but that is not how the people should be defined.
Well,
rights,
in the very case that you mentioned, Verdugo or Quides, we held specifically in the context of the Fourth Amendment that the Fourth Amendment's reference to the people is confined to individuals with an established tie to the national community, right? And so in Verdugo or Quides, we held specifically that there was a threshold issue on whether on the scope of the right before we talked about the conduct, right?
Your Honor, in Verdugo or Quides, the court did hold that the scope of the people was the national community, but non-citizens can be part of that if the court does want to adopt a narrower definition in terms of the Second Amendment rather than all people. Non-citizens, documented or not, can still be part of the national community. And in terms of
we be adopting a per se rule that the Constitution applies to illegal aliens, or are you going for a second alternative to suggest substantial ties or connections to the community?
Could you repeat your question? I didn't.
Yes, are you asking for a per se rule that for all amendments and the entire Constitution applies to all people, undocumented or not, or are you going for a back stop to suggest that we could have a substantial ties or substantial connections to the community?
I'm not asking for a per se rule, Your Honor. There are certain rights that can properly be limited to citizens, and those are political or democratic rights.
Such as voting?
Yes, voting and jury service have properly been limited to citizens. And the right to hold federal office as well is explicitly limited to citizens in the Constitution, which shows that when the framers wanted to limit rights to citizens, they knew how to do so. But those rights involving self-governance or democratic participation, being a citizen is being part of those democratic institutions. So those rights are properly limited to citizens. But this court in Heller explicitly delinked the Second Amendment right to bear arms from any sort of collective purpose, state defense, militia service. That is not the meaning of the Second Amendment. So
What do we do about the language for law-abiding citizen?
Yes, Your Honor. The government does make heavy reliance on this term law-abiding citizens, law-abiding responsible citizens that the court has used in its previous Second Amendment cases. But that was just dicta. In none of these previous three Second Amendment cases did the court have to squarely decide whether the petitioners were people who could claim the Second Amendment right, and especially not whether a non-citizen could claim that right. The government says that trying to term this phrase as dicta is trying to excise Bruin from the Second Amendment jurisprudence, but that is not what this is doing.
But how do you justify that? Since in Bruin, we referred at least 15 times to the reference to the law-abiding citizens. So obviously in Bruin, we did not view law-abiding citizens as inconsistent with our holding, right?
As the government says on page 9 of their brief, this issue of whether the petitioners in Bruin could claim the Second Amendment privilege was undisputed. So the language it wasn't an issue in Bruin whether these people were part of the people. So the fact that the court wasn't deciding that issue means that that language was dicta. The term law-abiding responsible citizen is also relatively vague, and this was discussed by the Third Circuit in Range v. Attorney General. There are plenty of people who aren't technically law-abiding, who we don't take their Second Amendment rights away. People who commit traffic violations and even plenty of misdemeanors aren't disarmed because of that, but they're still not law-abiding. Responsible is an equally vague term. So if this is what the court was using—
Citizen surely isn't vague as applied to this context, is it?
Citizen isn't a vague term, but this whole phrase is one and the same. It's all been used together in the previous Second Amendment decisions, and this phrase itself was dicta.
So I mean, suppose that we agree with you that you get past step 1 of Bruin, and then we have to look at history and tradition. What about the history and tradition of disarming people who, are not seen as part of the political community? And in particular, there's the government points to various Revolutionary era laws disarming British loyalists. Why isn't that suggestive of a limitation on the right that would apply here?
Those loyalty oath requirements are different in both how and why they burden the Second Amendment right to bear arms. And this how and why is what we need to compare to when looking to historical statutes. Those loyalty oath requirements were different in how they burden the right to bear arms because they often weren't categorical bans on possession. As the Western District of Texas described in United States v. Hicks, some of these laws, like Virginia's, for example, had self-defense exceptions. It still allowed people to retain the arms necessary for self-defense, even if they refused to take a loyalty oath requirement. 922 G5A is a categorical ban with no exceptions, self-defense or otherwise, so it's different in that way. These loyalty oath requirements were also different in their purpose. 922 G5A's stated purpose is crime control and protecting public safety. But these loyalty oath requirements were about preventing the overthrow of the government. They were trying to disarm people who were actively resisting the U.S. government, supporting people fighting against the U.S. government, which is not something undocumented people are doing.
We did say in Bruin that it need not be an historical twin. And why can't we analogize during the Revolutionary War era, the disarmament of Catholics, of Native Americans who bore no loyalty to the United States, much like we would analogize to undocumented non-citizens who also bear a loyalty to their country. They too, like in the historical context, could at least seek adjustment of their status to lawful permanent residence, in which they would bear a loyalty to the United States. They do not bear a loyalty to the United States, much like those historical examples that you were addressing, right?
The government does suggest that loyalty or citizenship can be used as a proxy for loyalty, but that isn't a fair comparison to make. It appears much easier to have taken these loyalty oath requirements than to become a legal resident or a citizen. The government suggests that someone can just adjust their status to become a legal resident or a citizen, but these pathways to legal residency or citizenship are expensive and can take years. And many people who come to the U.S. Unlawfully only decide to do so, make the difficult decision to do so after they're unable to access.
Why does it matter?
Why does what matter, Your Honor?
Why does the cost and the difficulty of an adjustment of status in the modern era matter when we're comparing 922G5 to the historical predecessors?
This falls into the category of how it burdens the right to bear arms. Those loyalty oath requirements, one could simply take the loyalty oath and regain their arms. But this is a much more difficult barrier to overcome in claiming that Second Amendment right from the government. So
well, I mean, it was only easy to do if you viewed, renouncing your loyalty to your lawful sovereign in Britain as a trivial thing, but for the people who didn't want to take that oath, like that was a big deal, right? So I guess I have the same question, which is, it's not so clear to me why the difficulty is relevant or which way that cuts.
The difficulty is relevant because there are many non-citizens who are here unlawfully who do want to become legal residents or citizens but don't have the pathway to do so. And that's what makes it different. If someone didn't want to take a loyalty oath requirement, that would be similar to someone who is here, didn't want to become a citizen or legal resident. So they're different in that way.
You mentioned earlier about public safety being an interest. So whether you have heightened scrutiny or rational basis review, that's still going to be a concern in terms of a compelling governmental interest, in terms of border protection, the false IDs, the inability to trace the person or the guns. So how do you speak to that?
Yes, Your Honor. On the Second Amendment issue, no form of means-end scrutiny should apply, as this court renounced that approach for Second Amendment challenges in Bruin. But in terms of the Fifth Amendment, heightened scrutiny should apply. And even when heightened scrutiny applies or rational basis, we recognize that public safety is a compelling government interest. But the issue under the Fifth Amendment is that the statute isn't narrowly tailored to serve that interest. The statute, as Your Honor mentions, the purpose is crime control. But this tie between undocumented people and violence or dangerousness is attenuated. Out of the approximately 11 million undocumented people in the U.S., only 7.5% have any sort of conviction, and only 2.5% have a felony conviction, showing how this tie between undocumented people and committing crimes or violence is strained. The government in its brief suggests that the statute is narrowly tailored because approximately 1/5 of federal prosecutions are against undocumented people. But if that's narrowly tailored, wouldn't a statute disarming the other 4/5 be narrowly tailored? I don't think so.
Is your challenge on the Equal Protection Clause of the Fifth Amendment, is that a facial challenge or an as-applied challenge?
A facial challenge, Your Honor.
Doesn't your own client's situation belie the lack of a close connection between the goal of crime control and the means through 922G?
No, Your Honor. The statute captures all undocumented people and would have caught Mr. Sitladine, would have captured him within the statute, regardless of how many firearms he had, what his purpose was, which we don't know what his purpose was based on the record. We don't know how long he was in the U.S.
Well, we do know as a matter of public record, don't we, that he was charged in Canada for murder, for trafficking in fentanyl, right?
We do know that, Your Honor. We don't know how long ago that was. We don't know the facts underlying that case. We don't know how long Mr. Sitladine was in the U.S. We don't know much about his circumstances based on the record. But the point is that the statute captures all undocumented people, and that's why it's facially unconstitutional.
To what extent do we rely on this statistics or empirical evidence with respect to what you just presented to us? But then you would have the government suggest that, you know, they have statistics on felons, and that's why they've got the statute there, or they have statistics on domestic violence abusers, and they've got statistics there. So I'm just trying to get a sense of how do we use that information?
The statistics are relevant in terms of the Fifth Amendment inquiry, in terms of whether the statute is narrowly tailored or rationally supported. But in terms of the Second Amendment inquiry, these statistics shouldn't be taken as, shouldn't be used in the analysis if we're looking to history and tradition. But in terms of the Fifth Amendment analysis, it is important in terms of narrow tailoring to see if there's a basis for the statute. And here there isn't. Even if this court applies rational basis, there's no reason to believe that a non-citizen is more likely to misuse a gun, commit a firearm crime, because there's no reason the statute isn't rationally supported.
So if you are applying for a tourist visa to come to the United States from a country that's not in the visa waiver program, you have to fill out a very long application and lots of questions. Do you think Congress could add to that a requirement that you agree not to possess a gun while you're in the United States as a tourist?
I don't think that directly speaks to or is directly relevant to the issue here. The issue.
Well, maybe it is, maybe it isn't. But what do you think is the answer?
The issue here, 922G5A is targeted only at people who entered unlawfully. 922G5B is targeted at people who are here on those temporary visas. So that would be more relevant in terms of a challenge there. But I do think that if the government were to add a restriction like that, it depends on the approach the court takes to that people inquiry. We're suggesting that the people includes everyone within the United States, so that would not be constitutional, but further briefing would be required for me to fully assess that issue.
But then how do we reconcile that? I mean, we've said over and over that, over no conceivable subject is the power of Congress more complete than over regulation of the admission of aliens. And if that is the starting point, how can it be that Congress can't impose, not possessing a gun as a condition of admitting someone into the country?
As this court said on page 23 of Bruin, page 636 of Heller, the enshrinement of constitutional rights necessarily takes certain policy choices off the table. And that's what we're seeing here. The court isn't speaking to the wiseness of what Congress can do. The court is looking at, is Congress following what is in the Constitution? The Second Amendment right to bear arms is in the Constitution, and we can't.
So is, as my colleague has referred to in the Diaz case, so is the Congress's plenary authority over the admission of citizens under Article 1, Section 8.
This is true, Your Honor, but when Congress's powers come in tension with Second Amendment rights that are any rights that are guaranteed to the people, the court does have to make a decision of which of these powers and rights are we going to value more. And because this court has been so persistent in stating how important the Second Amendment right is, that right should win out. The government in its brief suggests that Mr. Sitladine is claiming an affirmative, unconstrained right to possess, for all undocumented people to possess firearms. That is not what Mr. Sitladine is doing. Mr. Sitladine is challenging the singular statute he was charged under. He is not saying that undocumented people aren't subject to any other firearm laws, state or federal. Everyone will be subject to those laws. It is not an affirmative, unconstrained right that Mr. Sitladine is asking for here. Under the Second and Fifth Amendments, this statute is unconstitutional. Undocumented people deserve the right to defend themselves, their families, and their homes, and the court should strike the statute down and reverse the Eighth Circuit's decision. Thank you, Your Honors.
Thank you, counsel. The court will now hear from Ms. Pan, counsel for the respondent.
Thank you, Mr. Chief Justice, and may it please the court. My name is Chloe Pan, and I represent the United States as respondent. Section 922 G5A is a federal statute enacted by Congress more than 55 years ago pursuant to its plenary authority over national security and immigration policy. As Justice Miller and the Chief Justice just alluded to, this case is not just about the Second Amendment. It threatens Congress's long-standing authority to dictate the conditions that non-citizens must meet when they choose to cross the American border. Every single circuit court to have assessed Section 922 G5A has affirmed its constitutionality, and this court should not depart from that uniform conclusion. First, the statute does not violate the Second Amendment. Temporarily disarming non-citizens for the duration that they are illegally present in the United States is a straightforward application of this court's own principle that only law-abiding, responsible citizens may avail themselves of the Second Amendment.
But when the Constitution was written, many of the people were not born here and came into the United States. So if we're looking to the fact of them being non-citizens and having these rights, how do we look at that in terms of history and tradition?
Yes, Your Honor. In Heller itself, when the court specifically looked to the people, it acknowledged that to sort of square that circle, the people is a term of art. And so the way to define it in the context of the Second Amendment is to look at how the Second Amendment was understood at the time of our nation's founding. And in terms of that, we can look to what the Second Amendment came from. Now, the Second Amendment came from the English Declaration of Rights, and the English Declaration of Rights itself acknowledged that the right to firearms in the context of English common law was only available to those who were deemed to be subjects of English common law. And that was a direct relationship that was imported into the Second Amendment at the time of the Second Amendment's enactment in 1791. And so with respect to taking into account that individuals might come from different places, the key linchpin of this analysis has to be to what extent those individuals are part of the national political community.
How do we apply that historical prism based on the fact that in 1791, African Americans were not subjects of the United States? They were not even considered people. At least 5/5 of an individual. So are we to, for stage 2 of Bruin, are we to, how do we deal with those sort of historical anomalies?
Certainly, Your Honor. And in Bruin itself, this court acknowledged that when it engages in this type of robust historical analysis, it will often require difficult choices in terms of what cases are appropriate to rely on. And here I would say that this court can look to examples at the time of the framing and derive general principles to say that this court has deemed certain groups of individuals to say, in the context of the Loyalist example, to fall within categories of dangerous outsiders. But this court does not have to agree with the groups to which that label was ascribed. And so with respect to the example of disarming African Americans, for example, that's an example of a classification that in the present day would likely be struck down on other constitutional grounds, and so it's not a particularly relevant example for our purposes. I think here, the most relevant example is the one that Justice Miller alluded to previously with the example of Loyalists and those who are deemed to be sympathetic to the British cause. Now, I want to take a step back here and acknowledge that as a threshold matter, This court has never interpreted the Second Amendment to create a freewheeling affirmative right for any individual who simply steps foot on American soil to be able to claim the right to bear arms. Now, as was already discussed, Bruin established a new test, and so as part of that test, we look to text and history. Now, whether the court looks to the text of the people or the text of the conduct, ultimately what underlies all of this analysis is the history. And through either of those grounds, it is enough for the government to win. Now, specifically looking at the history of the Loyalist example.
Wait, I'm confused by that because I thought your position was that you only get to the history after you get past step one, where the Second Amendment's text covers the conduct, and it was your view that it doesn't. Is that right?
Yes, Your Honor. So I would say that there are two sort of different pathways that this court can choose to take in upholding this regulation. So first is that as a threshold matter in terms of looking at the people of the Second Amendment, this court can decide that individuals who are illegally present and non-citizens of the United States do not fall within that category.
And why? I mean, so can people who are unlawfully present in the United States be subjected to warrantless searches without probable cause, do you think?
Well, in Verdugo or Quiedez, the court specifically acknowledged that when it comes to those who have not demonstrated sufficient ties to the United States, then they actually may, in fact, not be able to claim Fourth Amendment rights.
But that was a Mexican citizen in Mexico, right? That was not a person unlawfully present within the boundaries of the United States. And I don't know that we've ever held that anybody within the United States is not part of the people for purposes of the Fourth Amendment, have we?
No, Your Honor. And in that case...
So I mean, did you think that there's a reason that the people means different things in the two different amendments? Or is the consequence of your position that illegal aliens don't enjoy protection under the Fourth Amendment?
Well, Your Honor, in Heller, when this court distinguished the First, the Second, and Fourth Amendment, it noted that when it looks to the definition of the people, it turns on how those amendments existed at the time of our nation's framing. And so taking that analysis into account, the court can define the people with respect to the Second Amendment in a way that does not have to apply to the First and the Fourth Amendment. But assuming that the court does find analogous reasoning by looking to other amendments, there is a case such as Turner v. Williams in the context of the First Amendment, where the court has acknowledged that when an individual is not a citizen of the United States, then any arguments that they try to make, for example, challenging immigration regulations on First Amendment grounds, that those are inherently unpersuasive. Now, with respect to the Second Amendment in particular, ultimately, all this court needs to decide is that those who are both non-citizens and illegally present in the United States simply do not fall within the category of the people of the Second Amendment. And that's a straightforward application of this court's own analysis in Bruin, where acknowledged, as the Chief Justice recognized, no less than 15 times as a threshold matter, that those particular petitioners were in fact American citizens.
How do we reconcile that? You were going to say something.
No, go ahead.
Justice. How do you reconcile that argument relying on our dicta in Bruin, our dicta in Heller, as well as in McDonald, with the text of the Second Amendment circumscribing the right to bear arms to the people? What is it about the term the people that connotes the idea that someone has to be law-abiding or responsible or a citizen?
Well, Your Honor, in McDonald, although the court sort of discounted the prefatory cause of the Second Amendment with respect to the militia, the linkage of the people in the context of militia would suggest that the purpose of the Second Amendment is to allow for lawful self-defense of the home and hearth. And with respect to individuals who have not developed sufficient ties to the United States in order to be part of the national political community, those are groups of individuals who cannot lay claim to a home or hearth within the United States. And so it is for that reason that in both Bruin, Heller, and McDonald, that in this line of cases, the court, as a general threshold matter, has always first looked to whether or not the petitioner in question was in fact an American citizen. And so before even looking to the actual regulation in question, the court would first confirm that those were categories of individuals who are either law-abiding or constituted responsible individuals.
Do we then look on a case-by-case basis to assess this facial challenge to determine whether an undocumented non-citizen is staying at a YMCA, for example, where they do have the right under McDonald to self-defense, or if they are homeless, they do not. Is that the sort of case-by-case parsing that we should undergo?
No, Your Honor, it's not necessary for the court to focus on the conduct matter if, when it looks to the status of the individual and determines that there, as a threshold matter, that is a group of individuals who do not fall within the Second Amendment's ambit. And I would also emphasize here that while I imagine there are certain edge cases that the court might think of, this case in particular is not a particularly close one. The class of individuals that petitioner represents are those who are neither citizens of the United States nor legally present in the United
But
States.
they certainly have the right to defend themselves, which we said at McDonald is the core of the Second Amendment. Why do they not enjoy as much of a right to self-defense as I do?
Well, the linkage in McDonald in terms of the right of self-defense, the court linked that to the focus on self-defense of the home and hearth. And so that would suggest that separate from this general idea of defending oneself out in the public, there's something about the private domain of the home that especially warrants protection with respect to the purpose of the Second Amendment. And so when it comes to a broad category of individuals, such as those who are legally present in the United States, they do represent a heterogeneous group, and it would be impractical for this court to say, for example, have to make these individualized determinations to say that this individual does have a home or this person was present at a YMCA. This court, in this case, can write a narrow decision to simply say that these two factors, both in terms of not being an American citizen and being illegally present in violation of federal immigration law, that combination of those two factors is enough to take those people outside of the scope of the Second Amendment.
But if you have, in the facts of this case, the seizure was for false IDs, you had over 60 firearms, you had fentanyl, which is can be a lethal drug, and then you also had that Citladine was wanted for murder. When you think about that, that could have led to a 922G offense for a felon, for example, and we say that felons should not have guns. If I look at that factual situation, what is it about illegal status that makes this different? I can understand protecting against felons who might be considered to have a propensity to commit other crimes, and that might bear out. But what is it about illegal that made that any different?
Yes, Your Honor. There are two dimensions to why the immigration status is particularly relevant in this case. So first, the sort of constant theme that's been the background of this entire conversation is Congress's plenary power. And when we think about Congress's right, or the framers' rights, to dictate sort of what communities fall within the scope of our national political community, it elevates questions of immigration and citizenship above and beyond sort of your typical criminal violation. Now, the second condition that is also relevant is that individuals who are illegally present in the United States have already violated at least one, if not more, federal immigration laws. And that different dimension of those types of laws, separate from criminal felonies, is a unique dimension that this court should take into account with respect to this matter.
Right, but the plenary power is the power to exclude, right? And that, I mean, that you mentioned a minute ago, Turner against Williams, right? That was about excluding somebody because he was an anarchist, right? So he wouldn't be allowed in. I don't read that case to stand for the proposition that, you know, once somebody is here, that the government can say, well, you know, because you're not a citizen, we can, for example, you know, restrict your speech on the basis of its content. And so doesn't the same distinction apply here? That what we're talking about here is not excluding anyone from the country. We're saying, you know, there's a class of people who are here, and we're depriving them of you know, an asserted Second Amendment right. So how does the plenary power doctrine help you do that?
Well, in Matthew versus Diaz, and also more recent cases like Patel v. Garland that this court decided just 2 terms ago, the court has conceptualized Congress's plenary power in 2 dimensions. So first, Congress can set the boundaries or the conditions that an individual must meet in order to enter the United States. But then the second facet of the plenary power is that Congress can dictate the conditions that those individuals must meet once they're within the United States and still maintain that non-citizenship status. And so that's particularly relevant here, where opposing counsel is claiming that what they're arguing for is not an affirmative right. But if this court finds that Congress, with respect to the Second Amendment, does not have the power to enact a statute that says that those who are legally present cannot carry firearms, then there's no other comparable version of this law that Congress, or any other state governments for that matter, would be able to enact. And so taking that practical consideration into account, it would functionally strip Congress of a fundamental element of its ability to dictate the conditions of presence once an individual has crossed the American border.
Right, but I take it you would concede that the greater doesn't always include the lesser, right? And so the power to exclude aliens doesn't include the power to impose just any conditions on them, right? So why is this an acceptable condition? Unless we already agree with you on the Second Amendment. I'm not sure how this is adding anything to your underlying position on the scope of the Second Amendment.
Certainly, Honor. So I would say that there are sort of two facets to consider. So one is going back to the actual historical analysis in terms of how these types of different gun rights restrictions have existed at the time of the founding and how they're comparable to contemporary regulations. The sort of operating principle is that Congress is allowed to make decisions with respect to non-citizens that it could not make with respect to citizens. And so that necessarily circumscribes sort of Second Amendment rights that Congress or the framing generation might set for certain communities of people. Now, the second element of that is also taking into account the fact that, in essence, the statute operates only as a temporary restriction. So what I mean by that is that the statute uses is language rather than has been language. There are other provisions of the 922G statute that say, for example, once someone has renounced their citizenship status, then functionally they can never avail themselves of the Second Amendment, and there's no way for them to bring themselves within the Second Amendment's ambit. But here, because the statute deploys is language, it still creates a possibility that in the future, an individual who at one point was illegally present in the United States could then go through the process of legal adjustment to become legally present within the country and therefore avail themselves of the Second Amendment.
How does that fit into the two-part analysis in Bruin?
So this particularly comes up in the context of these historical analogies, because in the context of these historical analogies, as was previously alluded to, when we look at loyalists or rebels or those who were deemed to be disaffected to the American cause, they could take what was described as a loyalty oath that is the functional equivalent of a modern-day citizenship pledge. Now, I take the previous discussion that, of course, there are differences between applying through legal adjustment of status as opposed to, say, taking a fealty oath. But the underlying premise and principle is the same, that there is a possibility for that person to prove their connection and commitment to the nation and therefore avail themselves of the Second Amendment. Now, I also want to address opposing counsel's Fifth Amendment equal protection arguments. And at the onset, I would counsel this court to be wary of imputing any sort of means and scrutiny into a Second Amendment analysis. Although opposing counsel attempts to sort of separate these and say that they're distinct arguments, ultimately trying to use equal protection to raise a Second Amendment argument does nothing more than re-inject the exact same means and scrutiny test that this court disavowed in Bruin.
Why?
Well, historically, the way that equal protection analysis has been deployed as distinct from due process is that equal protection has been used to defend implied rights. So, for example, education in Plyler v. Doe or public benefits examples. But when it comes to an actual fundamental right like the Second Amendment, the petitioner's claim should rise and fall under the Second Amendment itself.
But that's why I'm asking you why. In McDonald, we specifically said that the right to bear arms goes to the core of the Second Amendment, and it is a fundamental right based on the concept of ordered liberty under Washington versus Glucksberg. So if it is a fundamental right, we absolutely have to apply a compelling governmental interest and look closely at the strength of the governmental interest and the existence of a close tie. And we've already resolved that, haven't we, as far as a fundamental right in McDonald?
Yes, Your Honor, there is no question that the Second Amendment is indeed a fundamental right, and there's no contestation over that. The main distinction here is how the court applies an equal protection analysis. And as a general matter, when it comes to decisions like immigration policy, this court has never applied anything more than rational basis review. Now, opposing counsel may attempt to argue that this case warrants heightened scrutiny through two different pathways, both of which are foreclosed by this court's own precedents. First, they might attempt to claim that those individuals who are undocumented fall within a protected class, and so that in and of itself warrants heightened scrutiny.
But haven't suspect classes typically been those who have faced prejudice, hostility, they've been powerless and things like that?
Yes, Your Honor, that is correct, and it is for that reason why we believe that the class of individuals that are implicated by this statute would not cause this statute to be subject to a heightened level of scrutiny. In Plyler v. Doe, the court specifically stated that when an individual becomes illegally present in the United States, that is, quote, not a constitutional irrelevancy. Now, what the court was getting at in that respect is that it doesn't make sense to say that when a group of individuals collectively share a common trait of violating federal law, that then necessarily puts them into a class of individuals that therefore get protected status. And so that alone is not enough of a reason to apply any sort of heightened scrutiny in this particular case. Now, the second pathway that opposing counsel might attempt to argue is the sort of fundamental right with respect to the Second Amendment. But again, that argument should rise and fall under the Second Amendment itself, and they shouldn't be able to get a second bite at the apple by imputing this argument into the equal protection framework.
I mean, that suggests that the fundamental rights component of equal protection doctrine doesn't add anything to the underlying fundamental right? Because if what you're saying is, either he wins under the Second Amendment or there's no fundamental right implicated for equal protection purposes, but doesn't that vitiate that whole component of the equal protection doctrine?
No, Your Honor, because part of the equal protection doctrine, as Justice Childs was just alluding to, is the focus on classes that, for example, may have been historically subject to discrimination.
Right, no, that's right, but that's the suspect class part of it, but we also have a sort of heightened scrutiny for equal protection claims where the classification, although not itself suspect, implicates a fundamental right, which I thought extended to cases beyond just those where the right is being violated, because in those where the right is being violated, you don't need equal protection, right? So am I missing something there?
Well, to my knowledge, Your Honor, that type of analysis has not been extended to defend the Second Amendment in particular. And so here, if this court finds that petitioner's first claim with respect to the Second Amendment is unpersuasive, then it shouldn't then foresee a second pathway that is opened by the equal protection analysis in particular. Now, even assuming that that mode of analysis is relevant or applicable with respect to the Second Amendment, the only level of scrutiny that applies is rational basis review. And I would emphasize here that every single circuit court that has assessed this statute under the previous existing means and scrutiny before Bruin has still continued to affirm the statute's constitutionality.
Is the existence of a fundamental right relevant under the two-part test in Bruin?
Your Honor, do you mean the two-part test with respect to the Second Amendment analysis?
Yes.
It's
not, is it? I mean, your argument is that with regard to the status of the individual, whether or not we even get to the history and traditions, and your argument is based on the definition of the people, that we don't get to the second part of the Second Amendment analysis, and then you get to the historical traditions. And so back to my colleague's question, why is it the Fifth Amendment's antecedent question of whether or not there is a fundamental right, why does that devolve on the Second Amendment inquiry? Because the existence of a fundamental right really has no bearing on the two-part status historical tradition analysis in Bruin.
If I'm understanding your question correctly, Your Honor, the Fifth Amendment argument turns on the Second Amendment argument in particular because the Second Amendment is essentially delimiting the scope of that fundamental right. So going back to the Second Amendment, as I previously alluded to, there's sort of two different pathways that this court can choose to take in upholding the statute. So if as a threshold matter, the court determines that the people of the Second Amendment does not include those who are legally present in the United States. In other words, if this is the range of individuals who fall within the Second Amendment scope, then the statute itself, 922GA, is a direct mapping of that limitation. And so the necessary conclusion of that is that individuals who are legally present in the United States do not have a claim to a fundamental right with respect to the Second Amendment. Now, even in terms of the alternative pathway, which is that the court says that the people necessarily includes every individual on American soil, the court could still look to the language of the statute itself to say that as a comparative historical matter, there is enough evidence at the time of the framing to uphold the statute.
So if we take the approach articulated by then Judge Barrett in Cantor, and we say, I guess we would then say that you need to show that the people that you're disarming are in some sense dangerous. Do you lose then?
No, Your Honor. Under whether the court takes a scope of the right approach or a conduct-based approach, the government can still win under either approach. So the approach that Justice Barrett took in her dissent in Cantor specifically focused on this assumption that the people is a broad encompassing category. And so the real question is whether or not Congress can limit the application or sort of the group of individuals as a statutory matter. And that is where the second step of the Bruin analysis would come in. And there's no contestation here that there is sufficient evidence at the time of the nation's founding, whether it's looking at the example of loyalists or other state laws, for example, that existed in Massachusetts and Pennsylvania, that categorically disbarred individuals who were deemed to be foreign outsiders that were not part of the United States.
Not just foreign outsiders, dangerous foreign outsiders, right? I mean, like the loyalists were not just, people from another country who happened to show up here. They were people who professed loyalty to the country we had just been fighting a war against, and depending on the timing, maybe still were fighting a war against. So that suggests a sort of dangerousness that I don't think you have here, do you?
Your Honor, I think the sort of easiest way to think of a sort of taxonomy of who constitutes the people is to look back to the court's own language in Bruin, where it leaned on this notion of being law-abiding, responsible citizens. So I think one way the court could approach this is to say that as a general presumption, American citizens, as was implicated in Heller, for instance, that American citizens are presumed to be law-abiding and responsible. However, when an individual is not an American citizen, then if they demonstrate actions that either prove that they're not a law-abiding or that they're not responsible, that still takes them outside of the ambit of the Second Amendment. And where the dangerousness would come in that sort of elemental analysis is under the responsibility question. So when we're looking at law-abiding, we're looking at, has this individual, for example, comported with federal immigration policy? But when we're looking at whether an individual is responsible, that could be where the dangerousness assessment comes in.
But how do you justify that in the context of 922G5? Because the presence of an undocumented non-citizen is not a crime.
Yes, Your Honor, it is true that under the Immigration and Nationality Act, that the actual presence itself of being illegally...
And that's the trigger in G5, right?
Well, Your Honor, while the presence itself is not a violation of federal immigration law, the act that is necessary in order to become illegally present is. And so it is that initial threshold act in which an individual crosses the border in violation of federal immigration law.
What if Mr. Sitladine had come at the age of 17 with his mom and dad, and then he had 67 guns, and then he had a charge pending in Canada for trafficking in fentanyl and a charge of murder? Does the result change?
No, Your Honor. Irrespective of the individual's age, ultimately the main categorical determination that we're looking at is the fact of illegal presence. And so I hear in your example the possibility, for instance, of those who are children who might have been brought across the border at a very young age.
Because he never would have committed a crime.
Yes, Your Honor. I hear your concern about those who did not affirmatively commit an act. But where under this definition of law-abiding citizens, those individuals could sort of bring themselves within the ambit of the Second Amendment would be then to go through the process of changing their status such that they become legally present within the United States.
But if we think that you have to show, if we think that what law-abiding responsible citizen is sort of getting at is dangerousness,
Yes.
then, I mean, as was pointed out, you could have somebody who didn't commit any crime. You could someone who engages in essentially no conduct at all, right? That they come lawfully and then overstay the visa. So what is it about that suggests dangerousness with respect to firearms in the way that the other elements of 922, the domestic violence and the like, are all tied to, like, this is somebody who would be dangerous to have a gun. But what is there here that suggests that?
Well, I think that would go to sort of the two different elements of the law-abiding and responsible definition. So with respect to the example of a 17-year-old who maybe was brought into the United States as a child, they might not be dangerous with respect to the responsible element of that definition. But if they have not gone through the process of adjusting their status to become legally present, then they would not meet that definition of being law-abiding. And so I would emphasize that there are these sort of two different prongs with respect to both being law-abiding and being responsible that an individual must meet in order to avail themselves of the Second Amendment. And part of that goes back to the actual legislative history of the statute itself. When Congress was assessing the Omnibus Act that resulted in 922 G5A, it ascertained that for those who are legally present in the United States, they're often more difficult for law enforcement to track and often do not possess valid identification. And so that necessarily raises problems for other provisions of federal statutes that require, say, manufacturers or sellers to track where it is that their guns end up. And so when an individual, in this case, has not comported with federal immigration law such that they possess valid identification to allow for that proper tracking, that in and of itself creates an interest for Congress to try to ensure that firearms that are sold in the country can be tracked at the point at which they are sold. Now, a final point that I would also emphasize is that in none of its Second Amendment jurisprudence has this court ever, if I may briefly conclude.
Yes.
It is because of the implications of immigration that are raised in this case that no lower court has struck down this statute as unconstitutional, and we would ask this court to continue to affirm. Thank you.
Thank you. We'll hear from Ms. Nicolaitis for your rebuttal.
Petitioner has 5 minutes.
Wait just one moment.
Your Honors, I want to address the last point the government just made, that no lower court has struck down 922 G5A. That is not true. The Western District of Texas has struck down Section 922 G5A in a case notably where it was a Mexican citizen in the U.S. who had an outstanding arrest warrant for murder. So a court has struck down this statute in a similar situation, and this court can do so today. In its discussion of the people, the government, again, relies on this term law-abiding responsible citizen. But as the Eighth Circuit said on page 7 of the record, Bruin didn't define the people. This term law-abiding responsible citizen is not something that the court affirmatively said, this is what the people means. And the Eighth Circuit even recognized that in the decision below. The government, in its definition of the people, restricting it in this way, discounts the reality of undocumented people in the U.S. The majority of undocumented people in the country have been here for over a decade. And as Justices Miller and Bacharach alluded to, there are many people who were brought here as children, and these people never committed any crime when coming here. The government says that someone who came here as a child and then never adjust their status, that person isn't law-abiding because they never adjusted their status. But just because someone is unlawfully present in the U.S., that in and of itself is not a crime. That person isn't not law-abiding just because they never changed their status. After this, the government points to important government interests, tracking firearms from getting into dangerous hands. The government points to interests like this, and we agree that these interests are important. But as this court said on page 17 of Bruin, pointing to important interests isn't enough. The government has to affirmatively provide historical analogs to support the statute. The burden is not on Mr. Sitledine to show a lack of historical evidence. The burden is not on the court itself to sift through the historical evidence itself. The government must affirmatively provide you with those statutes. And the only examples they point to today are these British loyalist disarmament
Well, they also
statutes.
pointed to the English Declaration of Rights.
They pointed to that too, Your Honor, but the court in Bruin explained how some history is more relevant or probative than others, and that is the history directly at the time of the Second Amendment. So while that history surrounding England or history later on after 1791 can still be relevant, it's not as probative in determining the meaning of the Second Amendment when it was adopted.
Did the English Declaration of Rights not precede the ratification of the Second Amendment?
It did, Your Honor, but it preceded it. The most relevant history is that history right at the time of the enactment. Those the English Declaration of Rights did disarm certain groups of people, but those people were Catholics. And the reason for that disarmament was very similar to those loyalty oath requirements in disarming people who were viewed as active dissenters against the government. England's government still is tied with the Anglican Church, and that was the whole issue behind these disarming Catholics. Catholics were making there were two claims to the crown at the time from Anglicans and from Catholics. So the government was disarming those who were making the competing claim to the crown. Very similar to these British loyalist disarmament statutes during the Revolutionary period, disarming those who were actively fighting against the US government. Undocumented people aren't actively fighting against the US government. In fact, many of them want to be here. That's why they came here. There are many non-citizens in the country who feel a sense of connection and loyalty to our country and want to be here. In terms of the Fifth Amendment argument, the government says that we should only look at the Second Amendment here, but that ignores the nature of the Second Amendment right as pre-existing. On page 27 of its brief, the government incorrectly frames the Second Amendment as creating the right to bear arms. That is not what the Second Amendment did. It codified a pre-existing, fundamental, ancient, basic right to armed self-defense. And that is what the court should be looking at in terms of the Fifth Amendment inquiry. The government even agreed in its argument that the Second Amendment right is fundamental. Thank you, Your Honors.
Thank you. The court at this time will take a brief recess.
Folks, I'm sure you want to talk about what you just saw. Hi. I'm sure you're excited to talk about the amazing advocacy you just saw here. I will ask that you try to keep your voices down a little bit as we clear the room. We're going to hear presentations for the Best Brief Awards from an attorney from Crowell and Mourning in just a moment. For now, I'm going to escort your justices up to a room to deliberate. We'll be back in about 5 or 10 minutes, okay? Thank you.
Hello, everybody. Thank you so much. I'm going to be super brief. I'm going to promise to be super brief. I'm Jacob Canner. I'm a counsel at Crowell and Mourning. I'm here to present the Best Brief Award, but before I do that, can we congratulate our participants one more time? This is a very pro-clapping crowd, which I think is fantastic. I don't usually hear clapping at oral arguments. I think it's fantastic. It's awesome. Yeah, we should do more of it, right? That was a tough bench, and I thought you guys handled the questions with care and attention, and whatever the outcome, you should both be very proud of your work here. So congratulations to you both. So I'm here because I graduated in 2018, which feels like an extremely long time ago right now. And I'm also here because Crowell sponsors the Best Brief Award. Crowell and we're all very, very proud to be part of this award and to be part of the McBaine competition. It's an extraordinary competition. We're very proud to be part of it. Thank you, Natalie, who's up with the judges. Thank you, Dean Chemerinsky, and all the faculty that support this. Thank you so much for allowing us to be involved. So oral argument is very exciting, and I think today was very exciting, but I'm here to say very briefly why we should remember that the written word and writing is also very important. Brief writing is important because the brief is the first thing that the judge will see, and first impressions matter a lot. Brief writing is very important because the written word will endure on the desks of court chambers much longer than the oral argument and after the oral argument has concluded. And it's important because as a lawyer, especially as a young lawyer, the written word is the most powerful tool that we possess, and we should hone it, and we should work to improve it. So now I am so proud to announce our winners. So for petitioner, the winner is Kira Nicolaitis. And for respondent, the winner is Josh Cayetano. Congratulations to you both.
All rise, all rise. The court is back in session.
Please be seated. We're going to start with some general comments, I think, and we'll start with my colleague.
Right. So we have reached a decision, which I will not be announcing. And I will just start, if I may, by saying that this is actually the second argument that I have participated in, I believe, in this very room. The first being in March of 2006, when the Ninth Circuit had a special sitting here at the law school, and I was then a fairly junior lawyer at DOJ who came out and argued a case in front of a Ninth Circuit panel here. And I wish that I had been as fluid and articulate in presenting my argument back then as you both were today. You really did an excellent job. And so thank you and congratulations to both of you. And thank you to the law school for welcoming me back here. It's a pleasure to be here, and I've appreciated all of your hospitality today. I will say just a little bit more by way of elaboration on both of your performance today. I thought Ms. Nicolaitis, sorry, your again, for starting, very, very clear, nice, even pacing to the presentation. A nice job of sort of laying out some themes that you returned to a number of times throughout the presentation. And this is a case that there's a lot going on in this case, right? You've got sort of different lines of constitutional doctrine, a lot of history. I thought you made very effective use of the history and sort of distinguishing the parts of it that were bad for you and then relying on the parts of it that were good for you, and that was done very effectively. Ms. Pan, I say much the same thing about sort of tone and pacing and style, the stylistic parts of the argument. And on the substance, I'm going to focus on one thing that you did that is, I thought was very effective, that is very hard to do, and that is when you started out, you were only like a sentence or two into your opening, and you referred to some things that some of us had said in the first half of the argument. And I think, stealing a line from the Chief Justice, the first duty of Respondent's Counsel is to prove that he or she was awake during petitioner's argument. And it's a duty that a lot of people fail to discharge because it's hard to do, right? Because you come in with something sort of pre-prepared and you have to sort of ditch that or weave in something that's actually responsive to the argument that's been happening. And I thought you did that very effectively, and that was a nice touch.
You know, Natalie had to convince me that you are both law students and not experienced advocates, because both of you were absolutely unbelievable. And before I make too much commentary, I do want to thank all of you that put together this program. The bench brief was outstanding. The way that you all organized the materials for us was just really a delight. You all have just, made our day here just really a treat. And I know that required a lot of hard work, and all of us are so appreciative of that. But seriously, I just think both of you just did an amazing job. And one guarantee that I think we can all safely make is you both will be extraordinary advocates, because y'all already are. And we ask you both a lot of really hard questions, and I know you all have experience to get to this point, which is just really an amazing achievement. But your ability, your fluidity with the record, your ability to listen to the questions with, all of these people here is just really, quite amazing. And the poise that both of you showed was just absolutely extraordinary. We are so impressed, with both of you. And I think your ability to pivot. One of the things that was told to me when I was a very young lawyer about, it was really in the context of trying cases, but I think it's equally applicable to being an appellate advocate, is to be yourself, to be you. Some people, everybody has their own personality, their own style, and I don't know either one of you, but you both just came across so genuine, as what you presented there at the podium seemed to be your genuine selves. And that's very difficult when you're nervous, when you're in the finals of a very important competition. But I just can't express enough how extraordinarily impressed all of us are with both of you.
Thank you, and thank you, Dean Chemerinsky, for this opportunity to come here. And it's been wonderful spending so much time with you all in the various classes. And your students are so bright, so intelligent, and they really have peppered us with questions today, and I really appreciate that. I did last year, I'm a year and a half on the DC circuit. Last year I had a UC Berkeley Law student. This year I have a UC Berkeley Law student, so I had to come and see what UC Berkeley Law was about. So I definitely pleasantly surprised. You all were amazing. I really felt like you had calm demeanor. In all of my sessions, people ask me, what do you want to get from oral argument? I said, answer the judge's questions. You all did that today, because you shouldn't be on script. You should answer what we want to know. You didn't flinch. You were absolutely staying in touch with us. And sometimes if a question was convoluted, you were very kind and you rephrased it, but you still got back to what was the question that needed to be answered in that regard. I felt like it was clear in terms of the relief you wanted. You really, more than just knew the record, but nuances of the cases, because you were making distinctions, offering alternative paths and things of that nature. So I thought it was wonderful just the way you did your presentation, and it was at such a highly intellectual level. So that really told me all of the work and all of the preparation that you all put in here today. So congratulations, outstanding work.
All right, so I'm sure this is the moment many of you have been waiting for. I won't keep you waiting much longer. The 2024 James Patterson McBaine Honors Moot Court Competition is Chloe Pan. Let's also give a round of applause to Ms. Kira Nicolaitis for a wonderful job. Thank you all so much for staying with us on a Monday night. If you liked what you saw tonight and you want to get involved in McBaine next year as 2Ls or 3Ls, registration will open for the fall in just a month. Hope to see you then. Take care. See you later.